Now, the second category of errors I'm going to discuss are trial-related errors. And these errors began from the outset of the trial, beginning with jury selection, and they went all the way through closing arguments and even jury deliberations. And again, I'm not going to go through all 13 of the errors that we outlined in our papers, but I will highlight some of the critical ones that violated Mr. Smollett's constitutional rights. I think everyone can agree that this was one of the most high-profile cases in recent history. There was an immense amount of prejudicial pretrial publicity and an overwhelming presumption of Mr. Smollett's guilt long before a single piece of evidence was ever presented in a court of law. And this was in part due to a national press campaign by the former police superintendent, Eddie Johnson. And he went on national television on various networks, and he made blatantly false allegations of what the evidence in this case was. And there were three in particular, and these issues were never raised at trial because that's just not what the evidence was. Eddie Johnson went on TV and he said Mr. Smollett did all of this because he was dissatisfied with his salary on Empire. That was completely a false assertion, that there was zero evidence of that whatsoever, but he went out there and said that and put that in the potential jury pool. He also said that Mr. Smollett had sent himself the letter. Mr. Smollett fully cooperated. He gave his DNA, he gave his fingerprints to the FBI, not to CPD, but he did that to the FBI, and there was no connection between him and the letter. That didn't prevent Eddie Johnson from going out there well before this case ever got to trial and tainting the jury pool with that false assertion. He also said that Mr. Smollett paid the brothers $3,500 for the attack. And it was the brothers' own attorneys who went on TV right after that and said, no, this was actually as corroborated with a lot of text messages between Jussie and Abimbola Asundario. He had hired Abimbola as his trainer, and that's what the $3,500 check was in fact for. Now, based on this overwhelming presumption of guilt in this case, it was critical that jury selection be fair so that Mr. Smollett would receive a fair trial, if that was even possible. But there were fundamental errors in that process. First, the court violated Mr. Smollett's Sixth Amendment rights by preventing the defense from actively participating in the voir dire process. The defense sought to directly question the veneer, but the court denied that request. And although the court asked the parties and took questions from both sides as to certain questions that should be asked of the potential jurors, Your Honor didn't ask all of the questions that the defense requested. By refusing to allow the defense to meaningfully participate in the voir dire process, the court prejudiced the defendant's ability to discover those members of the potential panel with biases and or potential prejudices against Mr. Smollett, violating his Sixth Amendment rights. Although the court repeatedly stated that you didn't want to treat this case any different than other cases, this was an abuse of discretion in this case because of the prejudicial pretrial publicity, which could not be ignored.
Glandian, you guys required to ask every question submitted by your team to the denier, every single one?
We think we should have been allowed to participate in this process because of the unique circumstances of this case where there was such an overwhelming presumption of guilt. We think it's a very different process when the court asks questions and when we as attorneys get to ask the right follow-up, in real time without having to wait for, there were certain questions the court asked, and this was my next point with Rosemary Mazzola, where the court cut off the answers.
I asked most of the questions the defense requested of me. There's some I did not. For example, you wanted me to ask the denier, what kind of animal would you like to be if you had to be an animal? Or Superman or Batman, what do you prefer? Did you really think I was supposed to ask a denier when I'm choosing a jury in a criminal case, those kind of questions?
We identified certain questions in our motion that we think, I believe there were 4 questions that we thought were critical, not the ones Your Honor just mentioned, but there were important...
That was part of the pool of questions I received from you.
Right, but there were important questions that were not asked. And the more significant factor is we should have been allowed to question the veneer in this case. Again, I'm not saying in every case. I respect that Your Honor doesn't do that in a lot of other cases. However, this case is obviously unique. Mr. Smollett, unfortunately for him, has not been treated like anyone else charged with Class 4 felonies. He's been disadvantaged at every turn, and his jury selection...
I think a jury in this case the same way I think a jury in a murder case. I do the questions, I ask the lawyers for input, tell me what questions you want me to ask, I vet them, and I'm happy to ask the questions that are relevant and helpful.
I understand, Your Honor.
But just the only point I'm trying to make is that I absolutely treated him the same as everybody else. And I didn't distinguish him from a Class 4 offender, a potential offender, from a person accused of murder.
I understand, and I think, Your Honor, that's the problem here. A regular murder defendant doesn't walk into court with a presumption of guilt. Mr. Smollett did. There is a presumption of innocence. That was non-existent in this case, and that was due in large part to, as I said, the former police superintendent held a press conference. He went out and did a media campaign. The mayor spoke out on this case. Even Judge Tooman, in his order, before a single piece of evidence had been set forth before Judge Tooman, he convicted Mr. Smollett in his order. He talked about what a charade this was, and he made findings. And Judge Tooman should have been recused. We actually filed a motion for him to recuse himself because based on the face of the order, it was clear that he harbored bias against Mr. Smollett and was convinced of his guilt when he was not ruling on a motion that involved, there was no factual dispute before him. There was no evidence presented to him. And he nonetheless took it upon himself to make improper factual findings which evidenced his bias. He should have recused himself. However, he didn't even let us intervene in those proceedings to consider our motion for recusal and to consider our motion for reconsideration of the order appointing the special prosecutor. And all of that was error. But to Your Honor's point, the reason I think Your Honor should have treated this case differently is for all the reasons I stated, which is he does not sit and he did not come before Your Honor the same as other defendants with a presumption of innocence, which is what he is afforded and entitled to under the Constitution. Instead, he walked in. I've never seen presumption of guilt the way Mr. Smollett faced. And it deprived him of a fair trial, and the court should have taken precautionary measures during jury selection. There should have been more leeway in this particular case. We made that request, and with all due respect, we believe it was error for the court to deny our active participation in the voir dire process and to ask the questions that we thought were important to be asked.